Good morning. Welcome back. We'll begin executive action with proposed substitute House Bill 1155. Madam Vice Chair.
Thank you, Mr. Chair. I move that proposed substitute House Bill 1155H-1001.1 be reported out of committee with a due pass recommendation.
Move and second to the proposed substitute House Bill 1155H-1001.1 be reported out of committee with a due pass recommendation. There are amendments. Mr. Ranking Member, would you care to move Amendment Bakey 292?
Thank you, Mr. Chair. We will start by please move Amendment Bakey 292.
Bakey 292 has been moved. Discussion, Mr. Ranking Member.
So a rather simple, narrow amendment proposed to this underlying policy, which would broaden the description of the regulated entities that would have to abide by the terms of the policy to include state agencies and tribal nations. They are players in many of the subject matter fields described by the underlying policy, and we think it's appropriate that they would be included in the public policy end. Please vote yes.
Thank you. Respectfully recommending a no vote on this amendment. So the Consumer Protection Act does not allow remedies against governments or tribal nations in the first place. So there would be no enforcement mechanism against them, which is why they're not in the bill. Further discussion? All in favor of the amendment signify by saying aye.
Aye.
Opposed to the amendment signify by saying nay. Nay. The amendment is not adopted. Next amendment, Mr. Ranking Member, would you care to move Amendment Bakey 293?
Thank you, Mr. Chair. Please move Amendment Bakey 293.
Bakey 293 has been moved. Discussion, Mr. Ranking Member.
Thank you, Mr. Chair. This amendment, again, narrowly tailored. What it does is it clarifies when these transactions, these data transactions can take place, and it clarifies that there has to be some reciprocity. There has to be an authorization in order for a transaction to take place. Some of the language in the substitute addresses this issue, but we'd like greater clarification, and this amendment greaterly clarifies. Please vote yes.
Great, thank you. Respectfully recommending a no vote on this amendment. So this would take away the opt-in for the requirement for consent before sale of personal health data. That's important. That's one of the core protections of this bill, is that people have to consent before their personal health data is sold, as well as shared or collected. So respectfully recommend a no vote. Further discussion on the amendment. All in favor of the amendment signify by saying aye. Opposed to the amendment signify by saying nay. Nay. The amendment is not adopted. There are further amendments. Mr. Ranking Member, would you care to move Amendment Bakey 294?
Thank you, Mr. Chair. Please move Amendment Bakey 294.
Bakey 294 is moved. Discussion, Mr. Ranking Member.
Thank you, Mr. Chair. We have some concerns about the use of the term geofencing in this underlying policy. Our concern has partly to do with it's a technological term that is moving technologically as we go forward. And what this amendment does is it basically removes a reference to geofencing that we think may end up sticking the underlying policy in a technologically obsolete position. We appreciate what the goal of the mention in the underlying policy is, but we think it is begging to become obsolete. So please vote yes on this streamlining amendment.
Thank you. Respectfully recommending a no vote on this amendment. So geofencing relates to location targeting. It's one of the creepier ways that you can be targeted by personalized ads based on your exact physical location. There are some more than somewhat troubling examples of ads being served based on locations near particularly sensitive healthcare places. And that's, again, why it's one of the core privacy protections in the bill. So respectfully recommend a no vote. Further discussion? All in favor of the amendment signify by saying aye.
Aye.
All opposed to the amendment signify by saying nay. Nay. The amendment is not adopted. There are further amendments. Mr. Ranking Member, would you care to move Amendment Bakey 295?
Thank you, Mr. Chair. Please move Amendment Bakey 295.
Bakey 295 has been moved. Discussion, Mr. Ranking Member.
Thank you, Mr. Chair. This is the first of a couple amendments that look at the matter of per se violations of the state statute and this underlying policy. We're trying to get a reasonable handle on how these kinds of actions can be reasonably treated by the law. We're concerned that the existing language in the underlying policy is overbroad and it could create unintended consequences in enforcement. So what we're doing here is clarifying how per se violations could be used. Please vote yes.
Thank you. Respectfully recommending a no vote on the amendment. So there are a series of things that you have to prove for an action in the Consumer Protection Act. And the presumptions of this, particularly that's a matter affecting the public interest, that's not reasonable, are true in our judgment, whether the conduct is dealt with in an action brought by the Attorney General or whether it's brought by an action with private parties. our RCW does a number of approaches to the presumptions, one of which is this one, where it just kind of sets all of them as per se presumptions. So respectfully urge a no vote. Further discussion? All in favor of the amendment signify by saying aye.
Aye.
Opposed to the amendment signify by saying nay. Nay. The amendment is not adopted. There are further amendments. Mr. Ranking Member, would you care to move Amendment Bakey 296?
Thank you, Mr. Chair. Please move Amendment Bakey 296.
Bakey 296 has been moved. Discussion, Mr. Ranking Member.
Thank you, Mr. Chair. This is the second of our attempts to add some clarity to this matter of per se violations. We also are concerned generally about how the state's Consumer Protection Act is applied in this policy and, frankly, in other policies. So what this amendment does is it simplifies, streamlines, and removes some references to per se violations. And what we want to do here is not make sure that the Consumer Protection Act, which is a good piece of statute, isn't used over broadly. So please vote yes on this amendment.
Thank you. I respectfully urge a no vote on the amendment for basically the same reasons. This would actually remove all of the presumptions that I talked about in the past one, both for private plaintiffs and for the Attorney General. And again, typically in consumer protection statutes, there are a variety of approaches we take the presumptions. A major one is we have the presumptions, or we have some of the presumptions. This bill takes kind of the earlier of those approaches, has all the presumptions, and I think it's fine to do that here. Further discussion? Okay, all in favor of the amendment signify by saying aye.
Aye.
Opposed to the amendment signify by saying nay. Nay. The amendment is not adopted. There are further amendments. Mr. Ranking Member, would you care to move Amendment Bakey 297?
Yes, thank you, Mr. Chair. I'd like to move Amendment Bakey 297.
Bakey 297 has moved. Discussion, Mr. Ranking Member.
We are still concerned about the Consumer Protection Act and its use in the underlying policy here. And what this amendment attempts to do is put a reasonable limit on how the Attorney General's office can proceed if it does move with a CPA action based on actions anticipated by the policy. So while the two focus more on the per se elements, this tries to limit more how the Attorney General's office proceeds under the CPA, and we think it is a reasonable guardrail around this underlying policy becoming misused or a fishing expedition on actions which may or may not break the spirit of the law. So again, an attempt to put some guardrails around how this policy might be used in court. Please vote yes.
Thank you. I respectfully urge a no vote on this amendment. So this amendment deals with what's sometimes referred to as the right to cure, which conceptually, I've been okay with in a variety of contexts. I think it's not my preferred policy approach, and the reason for that is it generally doesn't exist in many other consumer protection statutes. I mean, it sort of ends up the Attorney General typically investigates patterns and practices of misconduct just for sort of resource issues, and when it gets to the point where it's sufficiently serious, just requiring basically a one strike and one free pass on violations of the law isn't really a great use of state resources when something has become sufficiently serious to warrant their attention. So respectfully recommend a no vote. Further discussion? Okay, all in favor of the amendment signify by saying aye.
Aye.
All opposed to the amendment signify by saying nay. Nay. The amendment is not adopted. Now, on final passage, because the amendment is not adopted, the motion to report proposed substitute House Bill 1155 out of committee with a due pass recommendation. Speaking in favor of the motion, this bill, as you heard in testimony, means to address issues related to data privacy, specifically as they relate to healthcare data. As we all know, HIPAA, the Federal Health Information Protection Act, has some protections for healthcare data, but does not generally cover all the healthcare data that companies collect, sell, or share about you in a really quite significant way and at quite significant scale. This is a complex issue, but it is akin to something the legislature has seen before. You may recall in previous versions of a privacy bill, there was a category of sensitive data that was opt-in consent, and that sensitive data generally included medical condition or diagnosis. This is broader than that, of course, but it is conceptually similar to the opt-in regime requiring affirmative consent that we've seen in parts of bills before. I do think this is reasonable. There's been a gigantic amount of work to refine the bill since the hearing, as reflected in the proposed substitute. The proposed substitute makes a number of changes, many at the request of people who testified or people aligned with those who testified on the bill to narrow the bill. So I think this is reasonable where it is right now, and we should move it forward. Further discussion, Mr. Ranking Member or whoever? Mr. Cheney, please.
Thank you, Mr. Chair. I join, I think, both parties in a concern over private sensitive medical data and wanting to be make sure that there's some protections around private sensitive medical data. But I remain concerned in this case because of the per se violation of the Consumer Protection Act language. That language, in my opinion, would, if a business were to make a good faith mistake, that per se language could immediately open them up to fines or suits. That's not to say that a consumer, if their data were to be somehow unprotected, couldn't bring a regular consumer action claim. They indeed could. And a court could hear that and they could still get damages awarded. But I think the per se portion of the statute opens the door a little bit too far to damages. Thank you.
Thank you. Further discussion, Mr. Ranking Member.
Thank you, Mr. Chair. I want to echo what Rep. Cheney said. I mean, our concerns about this bill are two parts. And he covered the first, which is a mechanical concern about the definition of this per se violation of the Consumer Protection Act. It's our concern in this policy that those terms in that act, which are well made, are being used too much and too broadly. So that's one concern. The other concern we have is that this bill attempts to combine two controversial sort of subject matters. The first being medical privacy, and in the testimonies we heard of supporters, specifically abortion rights and abortion access, to a long-standing controversial matter of data privacy. So whereas it certainly is a relevant news hook to compare these two issues, we feel it complicates rather than clarifies the ongoing debate over data privacy and how to protect people's data privacy generally. So we have a lot of concerns. While we appreciate the desire to clarify data privacy, we don't think this particular piece of work at this point in time is clarifying or strengthening. We think it opens up unintended consequences and an overbroad use of other statutes. So for now, we're going to be mostly no.
Thank you. Further discussion? Chair Wallen?
Thank you very much. I'm going to be voting yes today, but I do want to express my long-standing position that I would have taken Banky 295, 296, and 297. Under the Consumer Protection Act, you have to establish an unfair or deceptive act or practice occurring in trade or commerce that affects the public interest, and in a per se violation, those three things you don't have to prove. And it's not just because I represent the tech community, which is incredibly important to our economy in the state of Washington. It is because I also represent, I work in my day job in a business where I have a bunch of humans that make mistakes. So the assumption that an act by business is an unfair or deceptive act or practice is offensive to me. And a lack of a right to cure is offensive to me. So, as usual on this subject, I find myself emotional. I support women's rights and I support privacy and medical data. I support all the goals of the bill, but I just cannot abide the lack of a right to correct a mistake and the presumptions that our businesses are acting in an unfair and deceptive way. So I will be voting yes, but if these elements are in the bill, when it comes to the floor, I will unfortunately be voting no. Thank you.
Thank you. The Ranking Member would like to speak.
Thank you, Mr. Chair, for the indulgence. I just want to agree with and emphasize the point that Rep. Wallen has made there, particularly about the right to cure. We went very quickly through our amendments. I want to emphasize that right to cure, I believe, is an essential element of this policy if it's going to be implemented. That if there's a good faith mistake made, that an entity, a business or an individual should have the ability to make it right, to cure the problem before a legal recourse is taken as anticipated by this bill. So the right to cure is going to be a key piece, I believe, of our continued conversations as this bill proceeds.
Thank you. For discussion, clerk will call the roll.
Hansen.
Aye.
Representative Hansen votes aye. Farvar.
Aye.
Representative Farvar votes aye. Walsh.
Nay, do not pass.
Representative Walsh votes nay, do not pass. Graham.
Graham votes nay, do not pass.
Representative Graham votes nay, do not pass. Cheney.
Nay without recommendation.
Representative Cheney votes nay without recommendation. Entenmann.
Entenmann votes aye.
Representative Entenmann votes aye. Goodman.
Representative Goodman votes aye.
Representative Goodman votes aye. Peterson.
Aye.
Representative Peterson votes aye. Rude.
Nay without recommendation.
Representative Rude votes nay without recommendation. Ty.
Ty votes aye.
Representative Ty votes aye. Wallen. Wallen aye. Representative Wallen votes aye.
Does any member wish to change their vote? Clerk will announce the tally.
Mr. Chair, there are 7 ayes, 4 nays, 0 absent or excused.
Thank you. By your vote, you report a substitute House Bill 1155 out of committee with a 2-pass recommendation. Next